So legal vacation AttaAkyea ene Godfred Dame former attorney general omo akoho say eno ho nti no omo refuse say omo bekọ akọ defend omo client na court SMon AttaAkyea after say court SMon AttaAkyea say ombra na ombe appear before court no ye drop in ha e de emam lawyer AttaAkyea aba be breaking silence the silence now oba be breaking also no there the court na ye no no he's too old in the game just say sa legal vacation we hu nti no emma ne mbu embre bia so course Ghana has say since no oba game ni no legal vacation legal vacation enya afi na legal vacation na chief justice ebe panel judges bi ase omunkonko the case enti no he is fighting against a legal vacation trials na ekoso no and the chief justice nso ye no obekoso na one no enya adwen sa and right now no ono ankasa na no mutu no right now no o say obe withdraw from Addo Boahen case na the client no akofa lawyer fofra no any problem cause or fight against a legal vacation. Right now no as AttaAkyea lawyer AttaAkyea the tactical AttaAkyea instead to withdrawn from Addo Boahen in the case that ebusua ye de honsem ebra mo yanko na yanko ti silence the tactical AttaAkyea edituga efa legal vacation semona court semon no any matters arising na answer na be kon Ghana has a open computer papa and a laptop papa na we use Abura periodic computers and accessories ho and I'll be laptop papa na we using the location enya irakwan o Kumase Bokrom Estate Eli free number na egu screen as na dey ba kwa de wo me say okra low budget and a high budget ebusua o mema high quality laptop na we use mommy yanko na yanko nkuti ensmeko.
How you do that? Well, what about your client's interest here? You need to serve his interest. Today he was in court. He's been directed to come back on the 17th. If he doesn't come with you or come with another lawyer, he must do his own cross-examination. That is exposing him to great jeopardy.
Yes, that is coming from judges who have gotten their marching orders from the CJ and they should go ahead with the case. It's like the judge telling my client that, oh, if you have a toothache, go and find a carpenter, not a dentist. How can a judge seriously tell this gentleman that, look, where we are, the investigator is the one being cross-examined, but do your cross-examination yourself. I found it very weird, I thought he would tell him that, look, go and find another lawyer if this man is not coming. But I am not worried about what the judge is saying at all.
Congratulations.
This is a position you
Yes, I held for 7 years. There was, and something was my vice.
The vice, I remember.
And we...
You guys caused a lot of trouble. I remember, you guys, the two of you yourself. He's caused a lot of trouble. I remember very well covering the trouble you caused. But yes, he is the president of the Young Lawyers Forum of the Ghana Bar Association. Thank you, gentlemen. And I want to go to AttaAkyea first. Mr. AttaAkyea, thank you very much for joining us. You were not in court today when your client's case was called. Why? Do I have AttaAkyea on? Hi, Mr. AttaAkyea,
yes.
Can you hear me? Yes, great.
Yeah.
Great to have you.
Can you hear me now?
Loud and clear, yes.
Okay. Yes. I didn't see myself lending my energies and also my thinking and my being to what I see as an aberration. Because we have a tradition of the bar, we have the Courts Act, and we have CI 47 talking about legal vacation. My dear brother, just look at the linguistic evidence in the law. It's called legal vacation. It's not an ambulance trial. It's got nothing to do with anybody's pleasure. So you have the Supreme Court on vacation. The CJ himself is on vacation. Is that not so? But in the wisdom of the CJ, some judges should sit as vacation judges to deal with emergency situations only, which is by way of a motion. And even the motions are done now by virtual technology. You don't need to come to the court in the comfort of your conference room. You put on your tie, everything, and you start the motion, and that's it. So I'll ask this question. Why should the Chief Justice give a warrant to judges who have heard part cases of some special cases and say that those special cases, they should go for trial? So part heard cases should continue. And these are without the reference to the programs of the lawyers, whether the lawyers will go abroad to do some good medication, or the lawyers who go to the National Bar Conference, or the lawyers who travel, whatever. So I keep asking this question. What selective justice is the Chief Justice trying to foist on us? All the murder cases, all the manslaughter cases, all the rape cases, and other criminal cases that are part heard, they are not of consequence at all. The Chief Justice doesn't care about that he wants to bring a warrant that those cases should be given expedited hearing. But these two cases, which a lot of people are talking about, how it is so important to somebody somewhere, should be put together, and then the judge should continue. So I believe that I've come far. I'm not a little boy in the game for me to use one case to cancel the traditions, the practices, and the statutory provisions of Ghana.
But what about the junior lawyers in your chamber? Can they represent you in this case?
Well, the case is not for junior lawyers to handle. If you see what is going on in the realm, So I need to be there, because the one who hired me needs my experience and gravitas. I mean, to come to terms with a case that since Gordgesberg's, time of the Gold Coast, national security matter has never been a subject matter of an open trial. I think it's a small case that we are doing. A dangerous precedent that because of one man, let's cancel the whole of the submarine tactics of national security and put national security on trial. I don't think a junior, will be able to face such an unprecedented, case coming from the Attorney General. So I couldn't cede space to a junior to go and do this job for my client, with all respect.
But legal vacations are part of the architecture of the justice delivery system. And I notice you make the point that legal vacation and the vacation judges must only hear the motions, and as being said today, interlocutory matters. But I notice also that when it's the case of the matter before a judge is a substantive matter that a judge is already hearing, that judge is allowed to hear those cases as well. But in that same case, that judge can also hear interlocutory matters from other judges on vacation. But when a matter is substantive before them, they can hear those cases.
That is the election of the judge. But it should be referable to the convenience of the lawyers. So therefore, if the judge on his own motion believes that a part-head case in a land matter should continue, but the lawyers have traveled to Singapore, how is he going to secure, their buy-in to continue? Let's get it clear. And the warrant is telling the judge that continue with these two cases. That probably is very consequential for the Attorney General. So that's the selective justice I'm talking about. So if you want a part-head case heard during vacation, it behoves the judge to get the buy-in of the lawyers, because if the lawyers are not present, how are they going to conduct the case? Because of what the law says, they should go on legal vacation. And let's get it very clear. This particular one is a special thing for somebody, because probably somebody wants special results.
Explain that, because I've heard you make the point today. It's just for somebody wants special results. What do you mean when you say that?
Well, somebody believes that, at the end of the day, MPP could not jail some individuals, no? The whole of the time of the MPP, they couldn't do 10, cases successfully. And this is our time, and we've not done 2 years. We've secured about maybe 5 or 10 convictions. And therefore, so long as I am in a hurry to get people convicted, I'll push the lawyers to come and work during the vacation. That's how I see it.
So this is So this, as far as you're concerned, is part of a grand conspiracy to simply railroad your clients, get them fast-tracked convictions for the NDC to prove a point that the oral case, I believe, the oral agenda is moving along as was intended.
You cannot run away from this inference. Because what is the ambulance nature of this trial? What is special about this case? Why do we believe that, I mean, for whatever reason somebody is having, we should continue with these cases? And what about the other cases? They don't matter in the realm. Is that not so? Somebody has murdered another person. That's a part-head case. The judge who is doing the part-head trial is resting. So why Addo Boahen's case? So these are some of the matters that we should question the Chief Justice's discretion to give a warrant to a judge that, look, no matter what it is, whether the lawyers are ready or not, let's foist these cases on them and they should come and continue the trial.
If we take the suggestion of a conspiracy, then that suggests that the Chief Justice is part of the conspiracy in league with the NDC.
You are saying that, but is it not logical to you? What is the point of the matter? What is it that anybody is trying to achieve? Yes, if NDC would want to have convictions, it should go through the rule of law. And nobody should aid anybody to get somebody convicted. They should come to court and with the greatest of respect, let the system run and then prove beyond reasonable doubt. But you can't find anybody saying that, oh, this is the temperature of the executive. The judiciary should give aid to that so that people suffer, in a manner that even when the lawyers are on vacation, let's hold them because some people are in indecent haste to get some cases cleared off. I can't come to terms with that, I can't come to terms with that.
Earlier in your submission, you made the point that hearing of cases, substantive cases in a vacation court before a vacation judge, is subject to the convenience of the lawyers. And I've seen that articulated in the Ghana Bar Association statement, the letter they wrote to the Chief Justice. But if we are to take that point, though, you're suggesting that the administration of justice and the conduct of a trial is somehow subject to a lawyer's dictate and not that of the judge or the court.
Far from that. I've brought to your attention a very foundational issue, the statutory provision of legal vacation. If they believe that we shouldn't rest, what was the sense of the Courts Act and by extension CI 47? So it is envisaged under the law that the lawyers and the judges should rest. What is the meaning of legal vacation? Is it semantics or is it practical? And therefore, when a man wants to rest and a judge believes that there's a part-head case, a very prominent land in Pram, it's a subject matter of a trial and it's part-head, he should seek the buy-in of the lawyers that, are you able to come so we continue with the part-head case? Because we know that the bar and the judiciary, they are Siamese twins. If you separate them, it won't work. Administration of justice can't work. You need lawyers to appear before judges before cases are conducted. But how can you say that you want to run a case like an ambulance at the expense of who? So if the lawyers are arresting, it doesn't matter to you at all because somebody is an indecent haste to secure political convictions or criminal convictions or whatever conviction they are interested in. I believe that justice should not be hurried because of some people's convenience politically. They prove beyond reasonable doubt hasn't gotten party colors at all. And one of these days we will all see that at the end of the day, all those people who want to set aside the force of the law to catch up with them in future.
Mr. AttaAkyea, please stay with me. Let's explore the points you've made a bit more with your other colleagues. Roxy, he makes a very fundamental point, and I've seen that the MPP has articulated. He asks one simple question. Why is it that the hearing of the substantive case is restricted to these three high-profile political cases, which involves three members of the previous NPP administration?
Thank you very much. Let me say good evening to my big brother, I adore him a lot because it's very deep and erudite. And my brother, the new president of the Lawyers Forum, Young Lawyers Forum, as we used to call it. Yeah. Is this still the case?
Yeah.
Great. So you are welcome. Yeah. And our viewers. But my senior is wrong. And he knows that he's wrong. Look, I have data in respect of his office. Senior runs a chamber called AttaAkyea and Co. And he has about 17 lawyers listed as members of his law firm. And you see, let's place these matters in some context. What is the business of the GBA in this matter? The GBA has no business in this matter.
No, but the lawyers who have been affected are members of the association.
No. It's the lawyers. It's not the law firms. GBA is saying that they receive petitions from law firms. Law firms are not part of the Ghana Bar Association.
But the lawyers in the firm are.
Good. GBA didn't sit down. You see, GBA is an association of lawyers. And when we are lawyers, we are a community of reading men. And we deal with legalists. They didn't set the issues like that. They told everybody that they got petitions from law firms, not from lawyers. He's a member of AttaAkyea and Co. He's not a law firm. He's the one complaining. It's not a law firm that is complaining. So first of all, GB has no business in dealing with this matter because the law firms are not members of the Ghana Bar Association. The Ghana Bar Association is constituted by lawyers licensed by the GLC. The law firms, properly so-called, as we call them, chambers, they're also licensed separately by the GLC. So if you got a petition by some law firms, you ought to have written to them that there's a proper forum convenience for them to direct their petition. But I'll deal with the issues. AttaAkyea has 17 lawyers in his law firm. And in my formative years, there were some of the lawyers that when I arrive in court early and I'm able to find my way and handle my motions quickly, I sit and listen to them. It needn't take how long it took because they were such lawyers. They taught us law in practice and we have imbibed and we are here. He knows that the case is presently litigating will fall flat. These matters have always come before the law court. So as far back as 2000, the year 2000, Justice Badu in the matter of Boahen and Tai had cause to, it was even a civil matter. He had cause to say that where a hearing notice is issued and served on a lawyer and the party, and the party gets to court and the lawyer writes to say that he has made vacation arrangements, the court is minded to proceed with the matter. Unless the court is minded to give the party opportunity to produce another lawyer to deal with his interest in the matter, or the lawyer gets back quickly to say that he's prepared to return to court at a more convenient date. And I'll tell you, he knows that during vacations, I made some of my names at the bar from vacation trials. What will my boss do? He knows my boss very well, Teprehudu Chasaibo. He would travel for like a month and maybe and a half. So he will write. Normally he will write to the court that I am not available to handle the trial. But out of courtesy for the court, because the hearing notice has been issued for me to appear during the vacation, I will send my genius. So let them hold my brief for a copy of adjournment. So sometime in September, he will come and then they will agree on a date. Because you see, at the bar, we extend courtesies to the court.
He's explaining why he can't do that.
No, so let me tell you. And I'm also countering that with the number of lawyers he has under his watch. And he's such an excellent lawyer. He's been Jerry Rawlings' lawyer before. So he's such an immaculate lawyer. He knows that when you have genius under you, must give them opportunity to fly. And you use vacation cases sometimes to do that. So some of his junior partners could have gone to court to say that, our managing partner who is in control of this matter has maybe traveled for a couple of reasons. Those reasons will be stated. And therefore, he's pleading that he should be given a couple of weeks to return to take control of the matter. The court in vacation will grant you.
You're certain?
I'm certain because we've done it many, many times. Especially in October, if you pray that you want to return in September to come and deal with the matter, the court will grant you.
So you're saying, although the Chief Justice has said sit,
yes,
the discretion is left to the judge to decide. It is
always negotiation at the bar, between the bar and the bench, always.
So that if you don't appear before the judge, you will know.
Look, we were in this country 2023. Atuforsi was attending court every day. His lawyers at the time pleaded with the court that the everyday trial was most inconvenient. Why? Because they have other cases.
But that wasn't during the vacation.
Good. No. So don't, but they did it also in the vacation. Now, what the court eventually agreed with them is that, okay, instead of the daily trials, we can let you come maybe 3 days in a week so that we can have 2 days in a week to deal with your other clients. The same approach was done in the Jachikwesin case. Jachikwesin was ordered, his lawyers were ordered to appear in court every day. In these circumstances, do you prefer a daily trial to a vacation trial? I would prefer a vacation trial to a daily trial. Because the daily trial, the tournament of trial, every day, sometimes you get home in the night, before Jack, it is 6 a.m., you must get ready for court at 8 a.m. So the daily trial is not funny. And no lawyer should say that the order to do a daily trial is better than the order for a vacation. So I am placing these matters in some context. I'm saying that Senior AttaAkyea, bar politics, could have simply approached the registrar and the judge and negotiated that, for the month of August, it is fresh after July. I'm exhausted. I have some other arrangements with family and all that. So let me come back in September so that we do this. Nobody, no media would have heard about this. And it's something as lawyers we do always. Second.
But they petitioned.
Yes.
The CJ.
So I'm saying that the petition is what triggered all these debates that me and you and him is on Zoom looking at me. He knows that step was wrong, erroneous.
Why is that step wrong?
It's erroneous because once a hearing notice in law has been issued and directed at your client, our duty under LI 2423 is to provide legal service around the clock, every day, every month, and around the year, especially when you are paid for the service. That is why lawyers often will bill by the hour.
So are you saying that the petition was the wrong forum and that it should have gone to the judge?
It was first the wrong step to take, and it was also the wrong forum to direct the petition. Asking you using your chamber, because AttaAkyea could have used his own personal letter, that he is the lawyer in the matter, he's the one complaining. So then you complain to your mother body, which is the GBA, to now raise the matter on your behalf. That would have been more appropriate. But using his law firm, which is not a member of the GBA, they are an entity, an incorporated entity. It's not a GBA member. And GBA assume responsibility to canvass the interest of the law firms. To that extent, it's an erroneous step. But I am saying that 26 years ago, this matter was determined by the Court of Appeal. Justice Badu said, no, where a judge makes his private arrangements to travel during the vacation, and the warrant of the Chief Justice says that a certain court should sit and hear a matter, you, the party, you appear in court at the peril, to the detriment of your case. Because if you don't bring your lawyer, then you must either fire a lawyer, look for a new lawyer, or you call your original lawyer and say that this is the position of the court, and therefore I am looking for a lawyer interim. Do you understand? For the lawyer to stand in for me until such time that you return after pro tem. So the lawyer pro tem can deal with the matter. But the point I'm making is that AttaAkyea has so many lawyers who could have stood in pro tem for him and done a good job and acquit their managing partner in the matter. But he decides to go political. And look, if you look at especially his language directed at the CJ, he has been talking to me and coaching me about use of decorous language, both at the bar and in Parliament. AttaAkyea has supplied me over 10 books to read. Some I have not even returned to him. He's such a good coach. So I am at pain to crisscross him in this matter. But I think that it is not too late. We can still engage the court and say that, look, all this brouhaha, all this saga, let us tone down. And please give us a time in September to come. Look, it's not even, the judge themselves are not happy. Because normally when they sit in vacation, when they sit as vacation judge, then they take their long vacation when court actually resumes in October. So normally they return around November. Because it's tedious for them to continue from January, small vacation during Easter in April, they come back in early May, they work all the way to July, and then they are appointed to sit during vacation. It's tedious for them, but that is their call to duty. That is the oath that they swore to take. So vacation courses have been there before me, I was born, before I entered secondary school, before I became a lawyer yesterday. AttaAkyea has been going to vacation court before I became a lawyer in 2009.
Let me ask him if he will appear before the court, and then he'll come and answer a very important question that will come up.
He needs to withdraw the petition.
I'll ask him that. I mean, AttaAkyea, will you or any of your other colleagues in your chambers appear before the judge and make this request?
They will not. You see, first of all, my dear friend and colleague loses sight of the fact that it is not the judge that did a self-warrant. So if you say that my petition to the CJ is wrong, he loses the point totally. You see, the judge was selected by the CJ to come and do a specific job. Therefore, if you want to question the warrant, then you shouldn't go to the judge. As a matter of fact, at the last sitting, the judge was very emphatic that, look, I'm a servant of the realm. If they want me to sit, I'll sit. But if you have any issues, deal with the CJ, who has given me the warrant to sit.
What was the warrant to sit as a vacation judge to hear all vacation cases, or to hear specifically the Boahen case?
To hear specifically a Boahen case and some other cases, which some of them are apartheid. This is very critical. You see, if the judge is sitting as a judge of the vacation, and all manner of criminal cases you look at, I won't say one word about it. But I'm saying that if the judge is sitting and they've ring-fenced some critical cases for him to expedite the hearing, I believe that that is selective justice and it undermines the Constitution, and I'll fight it. So I want to make that point clear. Listen to me carefully. If a man is playing semantics with this and he's talking about a law firm and lawyer, I said, oh, my dear brother and friend, it's the lawyers who are the animals who are to be working. I never said that my law firm is going to work, but it's me who's going to work. It is not because I'm tired. It's not because there is something of a personal nature which I'm fighting, but I'm fighting a tradition, a system that has been hallowed by the Courts Act and CI 47, that there's a legal vacation. It's not a personal convenience or personal comfort that I want to secure. I'm saying that if you say there's a legal vacation, then let them do the emergency cases and the motions. But I will not accept an arrangement which means that, oh, these are ring-fence cases for all the troubles of the realm. Let's look at these cases and deal with them, because that is a heartbeat of the Attorney General. I wouldn't lend my support to that. And we'll advise ourselves.
But while you do that, what about your client's interests here? You need to serve his interests. Today he was in court. He's been directed to come back on the 17th. If he doesn't come with you or come with another lawyer, he must do his own cross-examination. That is exposing him to great jeopardy.
Yes, that is coming from judges who have gotten their marching orders from the CJ and they should go ahead with the case. It's like the judge telling my client that, oh, if you have a toothache, go and find a carpenter, not a dentist. How can a judge seriously tell this gentleman that look, where we are, I mean, the investigator is the one being cross-examined, but do your cross-examination yourself. I found it very weird, you know. I thought he would tell him that, look, go and find another lawyer if this man is not coming. But I am not worried about what the judge is saying at all. I'm challenging the foundational reasonableness and the decency of you saying that all the rest of the courts should go and rest. And that there are special cases that I want part head, and I'm stressing part head to continue. And counsel will agree with me that you can't get a part head case being adjudicated upon during vacation unless you get in the buy-in of the lawyers. Now look, are you ready that we continue on this land case? Would you be prepared for us to do the part head? But if you want to foist a case on a lawyer to do during vacation, do you know the implication? That's an arbitrariness of grave consequences.
Mr. Thatcher, again on your clients, I want to come back to that because I think the lawyers are having a good conversation, lawyers, judges, CJ. But at the heart of this is the liberty of your client. What does this position, you are fighting what you believe to be something must be fought in principle, but what does this mean for your client?
My client who wants the rule of law upheld. It is not this docket that constitutes the rule of law in the realm called Ghana. You understand? So my client really understands my position that, oh, I'm fighting a cause that by extension will eventually inure to his benefit. So I don't see how my client is affected at all.
He agrees that you should take this course of action that may expose him to great jeopardy.
Of course, because he can't change the cause I'm fighting and the principle I'm trying to uphold. And I'm telling you, let's all be very, very sensitive to what we are trying to do, that it is not one brief, you understand, that should hallow the rule of law. One case. What about the generality of cases that we should just, consign to, time? The lawyers in those mass cases, murder cases, manslaughter, they don't matter to the realm. They don't matter to the Attorney General. Let's consign them to October. But let's handpick some few cases that is the heartbeat of the Attorney General and push them. What kind of selective justice is that? A two-track system in which one is in an ambulance mode and the other is the normal mode. Oh, you people can rest, but these ones, we want to find, we want to push it so hard and fast to get some results that we have envisaged. Please, this is inconsistent with the Constitution. And if anybody believes that this is what is normal, it's up to them.
You mentioned that you will fight this. You've sent a petition. The CJ today publicly rejected that petition. I'm pretty sure you've heard him. What's your reaction to what he has said today? That the lawyers cannot dictate how cases are heard, and that it's wrong to say that because there is a vacation judge sitting on the substantive matter, then that matter cannot be heard until, of course, the vacation is over. Well, what's your position?
No,
what's your reaction to it?
No, we are too humble to dictate to the Chief Justice. The Chief Justice should pay obeisance to the law and the traditions and the practices of our courts. I didn't insert the vacation, legal vacation in the Courts Act. It's not my invention. And it's neither his too. So the Chief Justice is the first person, the first gentleman who should pay regard to the law. So the vacation is not my invention. So I can't dictate how vacations are done. But I will question the discretion of the Chief Justice. And it's embedded in the Constitution. Article 23 is there. If you go to 296, it means discretionary power can be questioned and have a right to do so. So please, I won't fight the Chief Justice as a person, because he's a man that I respect. But I'll fight the cause that he's trying to, defend. If it's inconsistent with the Constitution, I'll do that.
Beyond the petition to him, what else are your options?
I will not let my sinners out now, but I work towards, bringing these matters to the logical conclusion. Because it is not my personal preference which will hold sway, but we are worshippers of the Constitution of Ghana. As Christians worship the Bible. That is what I want to do. It's not like, Addo Boahen's case is so special to my law firm. No, that'll be a very selfish posture. There are value systems associated with the profession that I want those value systems hallowed. And I'll take every reasonable steps to do that.
So I was winning and some so our political highway. So AttaAkyea, the tactical lawyer, and you didn't want some Abraham about breaky silence. Mamma say, Nensama or the two that a legal vacation coso and home. Yeah, but I must say, some of Japan cocoa teaser and some way, and my aha, a gossip politics TV so.